Good evening, ladies and gentlemen. A very warm welcome to all our participants, dignitaries, and esteemed guest speakers to the digital session on Revised Consumer Protection Act, the Amended Act, organized by the IMC Chamber of Commerce and Industry. All participants will be muted to avoid any disturbances during the course of this session. To consume less bandwidth and have clarity, you're requested to stop video streaming at your end. Kindly post all your relevant queries in the chat section so that the same can be addressed during the Q&A session by the moderator. We appreciate and thank our sponsor for the event, Jimbrick Consulting OPC Private Limited. As we begin this very interesting interaction, may I request Mr. Swapnil Kothari, Managing Partner, S. Kothari and Company, Advocates and Solicitors, and a member of the IMC's Law Committee, to present the welcome address. Over to you, Mr. Kothari.
Thanks, Selby. Good evening, ladies and gentlemen, and welcome to this great digital event on the Consumer Protection Act, the Revised Consumer Protection Act 2019. It promises to be a great legislation, and hopefully, when administered and executed, as time passes along, I think it will promise to be one of the best legislations that India has ever had. And the object today of this, rather the objective of holding this event, is to apprise the participants as to the key features of this act and any other translatable amendments that could be possible in all the other corresponding legislations which may apply here, and maybe even unique different legislations, or maybe even depending upon if the speakers have their inputs on this, carve out a separate legislation also. And of course, Selby has thanked the sponsor, that is Jimbrick Consulting. I'm equally thankful to them for sponsoring this event, and I'm extremely grateful to my panel speakers, Mr. Anand Patwardhan, who's the ex-president of the Consumer Bar Association, and Rajalakshmi Rao, who's the former judge of the National Commission. And of course, after I moderate this event, there'll be another session for another hour, where the chair of the Law Committee and the managing partner of DSK Legal, Mr. Anand Desai, will be moderating that event, wherein he will have two other eminent speakers who will be Advocate Mr. Shekhar Prabhavalkar and Mr. Vijay Subramaniam, who's the CEO of the Quant Talent Management. So I welcome all of you to this event, and to tell you a little bit about IMC, it's an apex chamber of commerce, trade and industry in the Western region, with its membership base of about 5,000 members and over 150 trade associations affiliated to it. It represents an advocate's interests of over 400,000 business and industry establishments across the country from diverse sectors. It has 26 industry-specific committees of experts through which it provides policy inputs and recommendations at various levels of government, and organizes activities where eminent business and government leaders engage with its members on a wide range of issues to create an environment for a sustainable economic development. At IMC, I must say, that's one thing, as part of the Law Committee and all the committees that are there in IMC, I can very, very proudly say that we reboot ourselves every day to create meaningful reforms in the government sector, in the private sector, wherever possible, and ensuring that those reforms eventually take place as per the vision of our experts. We research in that direction. That is the reason why we have the motto of reboot, reform, and research. So I hope you enjoy this event.
Thank you, Mr. Kothari. I further request Mr. Swapnil Kothari to take us through the first session of the evening, features of the Amended Consumer Protection Act, as the moderator of the session. Over to you, Mr. Kothari.
Great. Thanks, LB. Let me first give a brief introduction of our two panelists. The first is Anand Patwardhan. He has done his schooling from Shivaji Military School at Pune and LLB from Government Law College, Mumbai, with a Bachelor of Commerce from Lala Lajpat Rai College of Commerce and Economics. He also holds a diploma in taxation from GLC, and he's a certified computer programmer and analyst. He is an advocate, a practicing advocate, and a business management consultant, and the proprietor of A&A Law and it comprises of junior advocates, associate firms in Delhi, Mumbai, and Kolhapur. He's settled amicably settled, if I may say so, 36,000 cases. Now that's quite an achievement in my opinion. And he practices in the spheres of criminal and civil laws, economic offenses, Prevention of Corruption Act, debt recovery laws, consumer laws, arbitration matters, and he's handled many PILs. And he was advisor and consultant to the EOW. And he's also a well-recognized consumer and RTI activist. And he's walked through several states of India dealing with consumer issues. He's visited many Middle East and European countries, also trying to propagate mediation, collaboration, etc. And he was the first person to be interviewed as a guest at the launch of the Prasar Bharati's FM 100.7, and also the first guest to be interviewed when the said FM became an all-Asia broadcast. He's been a weekly columnist on consumer issues in several publications and also appears on several channels propagating consumer activism, other legal aspects. He's a life member of the Chamber of Income Tax Consultants Association, Council for Fair Business Practices. He is also a life member of the Consumer Guidance Society of India. And he is a member of the Executive Committee, the Chairman, Mediation Committee, and the Mediation of Legal Aid Committee of Council for Fair Business Practices. And he was selected in 1990 for the International Visitors Program of the United States Information Service to tour United States for propagating various consumer laws and consumer activism. I'm very happy to have you, Anand, with us. The second speaker is equally well known. She has a BCom and an MBA from Osmania University, Rajalakshmi Rao, an MS in advertising from University of Illinois at Urbana-Champaign in the United States. He is the immediate past national president of the Indo-American Chamber of Commerce. In 52 years of its history, she was the first woman to be elected as the national president. She is also the founder chairperson of the All India Foundation of Deaf Women, director in Tech Mahindra Limited and other important corporate organizations. She's a managing committee member of the IMC. She's also an executive committee member of the IMC Ladies Wing. She's also on the advisory board of Council for Fair Business Practices. She has had the distinction of working for 18 years in all three levels of consumer grievances redressal court, that is the District Forum, State Commission, and the National Commission. That's, I think, which is an outstanding sort of a record to have, because you've been at all three levels of, the adjudicatory mechanism under this act. She's a former governing member also of FICCI, the first lady president of the American Alumni Association, former member of Damodaran Committee of the Reserve Bank of India to give report on consumer services in banks. She's also the former member of Insurance Advisory Committee and Insurance and IRDA, that is Insurance Regulatory and Development Authority of India at Hyderabad. She's the executive committee member of SCWEC and the SARC Chamber. She's authored about two books in fact, and received many awards. IBG Award for Business Excellence, Female 2020, Ambedkar Ratna Award given in the United Nations on the 125th birth anniversary of Ambedkar on 14th April 2016, Rajiv Gandhi Award for Excellence, Sword of Honor, that is Hind Ratan in Bahrain, International World Telugu Conference, Women of Excellence in FICCI FLO, which is the award for professional excellence in December 2013. I'm very happy to have you both. And first of all, I'd like to ask Anand to tell the participants and inform all of us about the key salient features of this act and what sort of departure has it followed from the previous legislation of 1986, and whether this departure is a meaningful departure or is it just a cosmetic job?
First of all, very good evening to everybody. Thank you, Swapnil, for a wonderful introduction that you have given. So sometimes I get surprised by what people say, and I really want to be worthy of all that they say. Thank you very much for that. Coming to our issue of Consumer Protection Act, the first act, which was 1986, was an act that came in for the first time where the consumer's interest and the consumer's protection was something that got importance. Till such time, we did have laws whereby if any consumer was cheated, he could be suing the person for cheating, or in case of any food adulteration, There were such laws under the Food and Drug Administration Act and those kind of acts where a person could take those kind of steps. But ultimately it would land that person, or let us say even in case where there has been cheating with regard to weights and measures. There were such provisions already existing, but then it would always land the consumer to be a victim of these kind of malpractices, and further the victim of what our justice system would take that person through. He would be a witness, and the prosecution would be done by the state, and that would actually just make him a witness. He would not be even compensated for the loss that he has suffered. I think that is where the Consumer Protection Act came in a very big way, where compensation became an issue where a person or a consumer who has been, I won't just simply say cheated, but where there has been unfair trade practice and he has been victimized, he has scope for redressal. And that redressal has also been made quite simple, where one need not go through the technicalities. Most technicalities of the Civil Procedure Code or the Criminal Procedure Code or the Indian Evidence Act have been kept aside so that a consumer can freely come to the court and make an application. Of course, over a period of years, that simplicity has now turned into something which looks quite technical. Nevertheless, there is one wonderful window through which a consumer can look for a bright future and for being compensated in case he has been cheated. So, original Consumer Protection Act did provide certain features where there were three-tier system where redressal could be taken care of. For example, at the district level, where initially they started with just 1 lakh, but over a period of time, the last Consumer Protection Act amendment, which came in 2003, got the jurisdiction for the district forum up to 20 lakhs. Beyond that, up to 1 crore was with the state commission, and beyond 1 crore, the jurisdiction would lie with the national commission. Besides that, there was also a system by which an appeal could be filed against an order passed by the district forum, and orders passed by the National State Commission, or though there was no scope for second appeal by way of a revision on a point of law to the National Commission, and also knock the doors of the Supreme Court by way of a special leave petition. There also was a system by which appeal against the order passed by the National Commission in an original complaint could also be agitated before the Supreme Court. Now, with this kind of a system in place, every district had a consumer forum. Now that particular nomenclature where the transition has started is where we had consumer district forums, which are now changed to be called as consumer district commissions. So now we have this district commission, state commission, and the national commission. So it's better to call, instead of calling it consumer fora, it is the consumer commission. This is a semi-judicial kind of a system under the Commission and Tribunal Act kind of a concept, where we have people at the district level who would be qualified to be a district judge. Along with the president, there would be 2 members who would also be assisting, and the law clearly says that president and at least 1 member who would be sitting and adjudicating a particular dispute that has come before it. The main concept here was how to resolve a dispute. The redressal of a dispute was one of the main issues. But over a period of time, and particularly there's a wonderful interpretation that our Honorable Supreme Court has brought into this particular act, giving it a wider scope, a huge scope, wherein almost all kind of services under the act were getting, under the sun, were getting covered. Here, particularly people who are harassed by banks, telephone companies, builders, that was a major issue and a major thing that came up with the judgment of M.K. Gupta versus Lucknow Development Authority in 1993. The Supreme Court interpreted that merely selling 4 walls is not what is expected from a builder, but he has to make it habitable. And in that context, there should be proper access. There must be commitment as to when the possession would be given. There has to be the required amenities that have been promised, and any of these deficiencies in the promise or the representation made would amount to deficiency of service. Apart from merely builders, even if it is a cooperative society who has taken up a job for construction activity for its members, or even let us say, government boards like the MHADA or the housing boards or such kind of development authorities who have taken up the task of development and construction would also get covered under the Consumer Protection Act. Another milestone and a major impact came when even the doctors for services, even the doctors were included. So the services would include, like I said, insurance, railways, that is your traveling, your lodging, boarding, hotels would also come in. So all these kind of under section 2O and to section 2M particularly, where it was defined what all services that could be brought under the net of the Consumer Protection Act. When it came to medical issues, there was a huge hue and cry raised by the doctors saying that most of these judges are not competent to understand the medical intricacies and just presenting some kind of a case that, well, I have suffered some kind of a harm may not always be resultant from whatever surgical procedure that has been done by a medical person. And of course, that issue was settled by VP Shanta versus Medical Association of India matter, where the Honorable Supreme Court said that the judges would be more concerned with the kind of evidence that is brought before it, on the basis of which what can constitute negligence that can be understood. So
all right, that's a very good observation of the court that you pointed out, Anand. Let me bounce that with Rajalakshmi. Rajalakshmi, he pointed out the fact that evidence is very important. As a judge of the commission that you have been earlier, of the National Commission, in fact, of all three fora, today, with the new act in place, do you think with the activism that the judges are showing in the other courts of the country, like be it the High Court or the Supreme Court, do you think that you would be as demanding of the lawyers or of the complainant about the evidence that needs to be presented by him or her to buttress his or her case? And or rather you would take a little bit liberal view and say that, okay, this much evidence is sufficient, and the other than that, the act itself provides me with a wider amplitude to deal with the cases and to do justice. Because oftentimes we find that a lot of cases are stuck or are not given due justice simply because of the very hard rules of evidence. And this is not criminal law, this is civil law. So I think evidence needs to be relaxed a little bit. So how do you think, would you be placed to answer this question or to look at it in a different way?
Evidence is most important, as you know, especially in cases where there are no bills and things like that. It's very important. But when it comes to certain cases of medical negligence, where earlier reports were never given by the hospitals, although repeatedly asked for all the discharge summary and the entire report of your stay, they would never give. Now, Medical Association has been told that you have to give within 72 hours about all the treatment documents and all to the patient at their request within 72 hours. It never used to come years and years also earlier. Repeated judgments and the commission's orders, finally, Indian Medical Association, now council has now made it mandatory that this papers have to be given immediately. Otherwise, they should always get fudged. So evidence get completely destroyed. So when I joined the National Commission, I found it very difficult because there's hardly any evidence in medical cases. It's already like old cases and nobody bothered about evidence. And the hospitals just never gave any evidence at all. And they would just fudge it, most of them. And I just didn't know how to actually write those judgments. And that time, Supreme Court judges, when I was just worrying about it, casually, when I met them at some, event, I said, I'm so worried because whatever I write, you're going to just send it back on my face. But justice is not being done. And I was really hassled because my heart was saying something else. And then they said, Mrs. Rao, if you feel strongly, you write the judgment quoting both the cases, because I was worried about Supreme Court has given cases of 2-member bench, both ways. So lawyers would really hassle you with both the judgments. They said, you, in the interest of justice, we will always look at it differently. That was the best suggestion that they gave me advice. Then I went into res ipsa loquitur. Facts speak for themselves. Somebody who goes for a tonsils operation, young boy, goes brain dead. and no papers are placed, no evidence of nothing, no documents. They didn't even say whose NS it is, nothing. So it actually falls upon the doctor and the hospital, especially hospital. Then Supreme Court also gave another judgment where they said it is a duty of the hospital to procure all the documents and also give the names of the people who actually treated. You can't say the doctor left and went away to America, or the nurse is not there anymore with us. We don't know where they are. They know everything, but they will not give you. They said it is the duty of the hospital. So a lot of things now have gone into place.
All right. One question. Since you mentioned that evidence is extremely important, I noticed that you don't have a law degree. But how sort of, should I say, is it an impediment, or is it in fact a boon not to have a law degree, so that you're able to look at the two warring parties in a natural, objective, judge-like, as if you are a judge at home to decide disputes between two siblings or two children, and look at them that way? Because what happens more often than not, that if lawyers will present to you all sorts of evidence, all sorts of things, and they might cite even overruled judgments. They may read portions of the judgment, which are selective in the sense which are applicable to them, but just 3 lines before. As Justice Chandrachud recently pointed out, that look, I always, whenever the lawyer starts reading from a particular paragraph's 5th line, I always look at the first 4 lines. So it's
yes.
So something like that. How difficult it has been, or how easy it has been not to have a law degree?
Actually, in my opinion, it was a boon, because I always thought differently from the bench. And I think all the lawyers across in all the commissions, all the 3 commissions remembered that, because when I asked questions, they would just not have that answer ready. They'd be looking at the side and the client everywhere. They're just not ready for that. So, you think differently. You think from realistic angle. In reality, I would always put myself in shoes of that, whoever is the complainant and whoever is the person. It's come all the way. There has to be something knocking on our doors. So I would feel for that person. If I were to be that, how would I deal with it? So I would see that way and think differently and ask certain questions which are very, very leading to actually decide the case. Many cases were decided like that. So I think it was good that I didn't have that formal law degree, although by the time I finished my district forum today commission, I've already understood, because we had held so many cases, decided so many cases. We had to read the law throughout, because lawyers would always present the case, and you're also sitting with the judge. So we would discuss that. So by the time I came to National Commission, that was not an impediment. I mean, I could easily manage.
Okay, fine. That's I think a very nice way of presenting it, and I think most of us also need to, initially we lawyers also look at things like that, but then when we start reading up the law, then we start thinking very legalistically, and then how to win the case best. If we are not able to convince the judge, we tend to confuse him or her, and then try to get our way around. Now the question that I have for Anand mentioned that through a series of amendments, things became, the district commission was up to 20 lakhs, then 22 1 CR for a state commission, and then over 1 CR for national commission. Now this act talks about 1 CR, 1 and 10 CR, and over 10 CR, the pecuniary jurisdiction, if I may say so. Do you think that change, that shift was necessary? Number one. And do you think that really helps?
Coming to, maybe just touching upon what Madam Rao just now mentioned, I would put it's more like Akbar Birbal justice. Khichdi pakana, and ultimately how this person got what was due to him. That was the kind of, the element that was introduced by having a non-judicial member also as a member of the particular bench before it. So when it comes to the issue where over a period of time, like I said, from 1 lakh to 5 lakhs, from 5 lakhs to 20 lakhs, and now the district commission has jurisdiction up to 1 crore. So this is not the only change that has come in, and to some extent, if I may say, a welcome change, because it would mean a lot of consumers would not have to travel to the state commission or up to the state commission in order to get their justice, but at their own district level, they could probably get justice. But one of the major changes that have been brought about, I won't say by an amendment, there is no amendment, the old act is scrapped. that has been repealed and it's replaced by this new act. Under the new act, a major change when it comes to jurisdiction is not where the claim amount is up to 1 crore or up to 10 crores for the state commission and about 10 crores with the national commission. Here, the major change I have brought in is the consideration that is paid. So now we are facing a situation where the person who may have an insurance for his factory worth maybe 10 crores or 20 crores, whatever, in case of any mishap, or let us say entire factory burned to cinders because of some fire or something, the premium paid could be just about 1 lakh of rupees or maybe less than 1 lakh. In such a situation, the consideration paid being less than 1 lakh of rupees, though the claim may be 15 crore, the jurisdiction would be with the district commission. And in such situation, since the consideration paid is less than 1 lakh, the filing fee or the court fee as they normally call, but here it's called filing fee, is zero. So a person who is actually filing a claim for maybe 15 crores has actually paid less than 1 lakh, and that is why his filing fee is zero. That kind of a situation has come, which I'm sure would be a learning process and would be definitely requiring some kind of a change in future.
Okay.
Let us see how the act takes us and the way people would respond and how the courts would be now capable of handling such claims which are beyond the pecuniary jurisdiction that is actually allotted to the commission, district commission.
So I feel it's very good if I can intervene.
Sure.
But I think we are not just talking about Maharashtra and Bombay. We're talking about many district fora, where I found over the years, district foras are not really ready for such, huge amounts to be looked at and to really look, because it's very important at the district forum and district commission, that's when evidence is led. That's the very first forum. That's where everything is put in place. So it's important the bench writes a correct judgment, taking everything into consideration. Earlier, it was different. It is a smaller amounts. Now, big cases are going to come. They must be trained properly across the country. All the district fora members must get trained to know how, the decisions have been given by Supreme Court and what is the thinking, so that they should educate themselves. You have to train them. Government must spend money on this.
Okay, fine. In fact, I was going to come to the CCPA part, later, where the Central Consumer Protection Authority, what sort of its duties, and I'll come to that. I'll weave in this point. But one of the other points that I have is that, e-commerce has been included in the new act. I think we are now not going to the brick and mortar shops, much right from when the online started, and much more so during the pandemic, because, sitting at home, I think with the great Wi-Fi, we can order even the shoes and every single thing that can cater to our whims and fancies. There is a tendency, from what I've noticed about the e-commerce people, to at times dupe people, and they tend to send you different things than what you actually ordered. Given the fact that legal proceedings can be cumbersome, do you think including e-commerce is a good idea, or do you think we should have left them to regular civil proceeding if one wanted to, and leave it to the NGOs? Say, for example, like Council for Fair Business Practices, an NGO where you can deal with these sorts of things, or even the mediation cell of the IMC for that matter, rather than bringing it within the purview of the Consumer Protection Act. What do you have to say on that, Rajalakshmi?
You're asking me?
Yes.
See, there has to be some fear to start with.
Okay.
Everybody must have this fear. Today, when you say, I'm going to go to consumer court, earlier days of Janik Jao, just go. I'm talking about 20 years back. Now, somebody knows that he has to get a lawyer. He has to spend so much money. And at the end of it, he has to pay interest, compensation, so many things for a very small thing, at the end of it. So now people have understood, people have really understood consumer protection. So now they are under stress. So they'll say, okay, I'll replace the whatever defective product or whatever. Some kind of fear is there. So now that fear has to come in. If you think, just let it be, it doesn't work. There has to be some kind of a fear.
Okay, I got it. I want to ask both of you a question. Deficiency of service means that something which you were to provide, you have not been able to provide. Say you were to provide 100 but you have provided only 60%. So that means 40% is deficient, and that's the reason why I can drag you under the Consumer Protection Act. I want you to think a little bit afresh, both of you, one from a legal perspective and from a non-legal perspective. One is from the legal perspective. I'll ask Anand this question first. There are several phone calls that you and I get during the daytime about credit cards, about several other unwarranted, unwelcome advertising requests, where people are advertising companies, top companies. They have put in all these people, on a 24/7 job. The morning, and there's automatic machine apparently which talks to you at 9:30 in the morning, which starts talking to you about, selling credit cards X, Y, and Z. According to me, should that also, these kind of things also be included in deficiency of service under the Consumer Protection Act? Because to stop that irritant value, where do I go? Is there a legislation? That's the reason why I asked Anand first, because I can't think of a legislation where I am bothered and irritated with these constant phone calls, and I cannot afford to block all of them all the time. What do I do? This is oversupply of service. That equally is irritant to me.
I feel most of these advertising and advertising calls are basic, something that has to start with, where people have to be made aware of. Consumer Protection Act, among the rights of consumers, are getting knowledge of the product, particularly not entertaining, but enlightening a consumer, not only about a particular product, but about his rights and the procedure that is available, is one of the aspects. The advertising, while that is one of the ways by which a consumer would be informed of what are the products that are available, where they are available, to whom they are available, which is one aspect.
No, but I don't want a phone call at 9:30 in the morning. I'll
come to that.
I'm in the morning. I want to have my breakfast peacefully. I don't want to be irritated with these phone calls. What do I do?
For that, as far as these kind of advertising limits are concerned, well, there should be some kind of a procedure by which the telephone call, the timing for the telephone calls and such kind of advertisement could probably be monitored or could be probably restricted. That is one way. Apart from that, basically, I'm coming to an issue where such kind of unsolicited calls can be stopped, because you have a service provider which offers you a DND, do not disturb kind of a thing. Notwithstanding that, there are so many private players who call up from private numbers, which is very difficult to identify and locate them. But then most of these calls are also marked by consumers who are irritated with such calls as spams. And then that is how they get floated, where most of these telephone companies have started now marking them as spams. Even if one of the consumer has done that, every time a phone call comes from that number, it gets marked as spam. I think the very purpose of getting this new Consumer Protection Act was because of the change in the market and the globalization of the market that we have. Today, sitting at home, looking at a screen, I mean, from where do you learn that, okay, these kind of products are available? You just open one of these direct marketing people, or any of these marketing, new media marketing people, as I would call them, and you've got a list of hundreds of kinds of printers, hundreds of kinds of television, hundreds of kinds of telephones, what kind of a model you want, which would be the best for you to choose. All those details are available. But then the total interaction is between you and the screen. It is only when you place an order, then it is someone who is taking that order, passing it on to someone who is actually selling it. From there, it may be going to some closest dealer who could actually be wanting to send it across to you. There could be certain schemes offered by different dealers with whom the best deal could be probably offered to you, and ultimately other kind of logistics, how this particular product reaches to you. By the time it reaches your place, there could be pilferage, there could be some kind of adulteration, spurious things happening, or there could be a wrong product delivered to you, or basically even though what was represented to you as a product, and actually that particular model reaches you, not the kind of model that you have been represented or shown, for which you have been lured into buy.
Right. Rajalakshmi, what's your take on this?
Actually, some years back when I was on the bench, we took it for a long time, called all the telephone operators, because someone filed a complaint on this, and realized that all these calls were being made, and it's a harassment to everyone. So we said, nobody should actually call without my, permission. They should not just call and tell me that you buy this or whatever. So we took it, to a higher level and gave decisions. But then at that time, we had Justice Karju in Supreme Court, and he just came out with this one judgment which ruled out all these complaints from the consumer protection. He just said all these should go to TRI or TDSAT as a group. Now, where are we all going to come together and, file complaints and go to Delhi? So it is just not workable. So entire country went stand still. Although our order was there, Supreme Court order, this sort of overtaken our thing. We went through for like 2 years on this deciding. And then government has to send a notification saying that, keeping Karju's judgment, they said department and government has decided it comes under consumer protection. But now the point is now who's going to file one case? So the best is what we said is that you'll have to have the option of, saying that I don't disturb me. Do not disturb.
Fine.
So I think you should file now another fresh complaint under the new authority where they can take it at that level.
Okay.
Central,
Central Consumer Protection Authority. Okay, fine. Yeah. Anand, Section 74 of the new Act talks about establishment of the mediation cell. It's a welcome move. It's a great thing to have. But when I looked at the mediation rules, I was looking through them. Matters not to be referred to mediation. Now, the wordings of this section, Anand, rather this rule, are the following: matters shall not be referred to mediation, namely, shall meaning it's mandatory that you will never be able to refer that. Okay, it's not saying may not be, it's saying shall not be. The first one is a little bit odd in my opinion. I don't know what the logic was. Maybe you know it. Maybe you can explain to our viewers. The matters relating to proceedings in respect of medical negligence resulting in grievous injury or death. I can understand death. Grievous injury. What is the meaning of grievous injury? That's an absolutely debatable issue as to what is grievous injury. For me, a fracture is a grievous injury. Some judge sitting there, may or may not think a simple fracture or normal fracture to be a grievous injury. And what is the logic behind not including these two aspects of medical negligence resulting in grievous injury or death? What is the logic behind this? That it should not be going to mediation and it should be decided by a court of law. Is it because of the evidentiary aspect that we are talking about that is required, that that real evidence which is required to show that this resulted in death or this resulted in grievous injury?
Well, Swapnil, I don't think that would be the reason.
Right.
Because when it comes to medical negligence, if that's death, then obviously there would be an angle where there would be further investigation, particularly death during delivery has to be investigated by the municipal authorities, and there is a procedure there. Similarly, any kind of death within 24 hours of being admitted to a hospital has to go for postmortem and has to go through the police procedure. So such kind of things where a death could be caused, not merely on the operation theatre because of something, but there could be other complications due to which there could be death, where maybe the anesthetist has failed to monitor the required parameters. Now, in such kind of a situation, it should not be a case where, okay, mediation means keeping all the evidence aside, we are sitting across and trying to work out the matter. Okay, how do you settle such matters? Maybe only by paying a certain amount, and if the consumer is satisfied, or the victim rather is satisfied, then okay, I accept this kind of money and everything is fine. Or maybe I give you a lifetime free of medical treatment to you and your family, so don't proceed against me. So these kind of issues need to be thrashed or understood before proper judicial functionaries. And why? Because it would have repercussions. I mean, if these kind of complications do happen, then the law, the government needs to understand that situation and probably decide on it at some stage. It should not be something that can be settled. I mean, it's something as simple, oh my God, I killed your child, don't worry, I'll give you another one. Now, what does that mean? So that's not something so simple. It cannot be something that can be, kept before mediation and accordingly worked out. So these are some of the areas where one has to be strict to follow certain procedure of mediation, where there could be a golden shake hand, certain issues, most of the issues could be ego issues, or some of the issues could be where a person is hurt. Jo karna hai karo, some attitude ultimately.
Yes.
Our policy we don't change. Ho gaya, toot gaya to toot gaya, we don't know. Such kind of things are where a person is brought to the court, and such kind of issues can be mediated and settled. So that is where there is one major issue. If you see the way we had mediation in a different way, Lok Adalat concepts.
Right.
Was very well, functioning, doing a very good job. So many of my 1,000 cases have been settled in Lok Adalat, though I was for the complainant and such kind of situations, or even for the opposite party, where we have worked out these matters. The golden shake hand, things are fine, both are happy, no further litigation, no further complications where a person feels, oh my God, I didn't get justice.
Okay.
Ultimately, even with the best award or judgment in hand, like Justice Krishna Iyer had said, it doesn't mean you have done justice.
I know, I understand. That's fair enough. I get the point. Now, Rajalakshmi, suppose there is a party, there's a complaint before you, which is not of a grievous injury. Would you, as a judge of any of the fora, any of the three fora, say that, okay, since the mediation cell, the rules of the mediation cell stop the mediation committee from looking at grievous injury or death, but normal injury can be looked at by them. Would you suggest that, okay, don't waste your time before me go to a mediation cell and try to sort it out, or would you want to do it yourself?
Different cases have different issues. Some people ask for money,
Okay.
They always ask for compensation. But certain others, like say a case where, just a small example, somebody was taken to ICU for orthopedic accident, elderly man, he had some heart and other ailments, and one of the reputed hospitals in Bombay, and in ICU, different problems came up, and different doctors, specialists came and gave a particular way of treating medicine. Different doctors said this. There was no proper duty doctor to put them all together and say what should be final. Each one said something. There's no coordination in that hospital itself how to treat this ICU patient. Finally, because nobody treated him to whatever that was to be done, he died. The point is, maybe you would have otherwise also died. That's a different point. How do you decide? Coordination of this is whose work? You have to see the entire documents and see who at what relevant time has given this medication and who else said what happened then. The entire sequence has to be seen. And then, it's sometimes they don't come just for money to decide it this way. They just feel, you have not done what you should have done for us.
Okay. There was no, this is to you, Rajalakshmi, again, and then I'll take the same thing to Anand. There was no CCPA earlier, under the earlier act. It's come under this act now. Why do I need a CCPA? Number one. Two, if I have one, do I tell them that, educate the district forum judges so that they write a good judgment, taking your point that you spoke earlier, so that, the litigation up the tiers is reduced? Because what I notice is that it's a great thing for people to still have that belief in the judiciary, and I, for one, firmly endorse that the judiciary today is the last resort and the only trustworthy institution for 125 crore Indians. We still say when we get angry that tujhe court mein dekh lunga. It's great to have that, but given the arduous procedures of litigation and going up the appeal ladder, do you think that the main function of the CCPA should be to educate the district forum judges who may or may not have a law degree? And don't take it as I'm not indirectly jibing at anybody who doesn't have a law degree. I'm just saying that to write judgments and all those things, it's sometimes that legalese is important. But just generically, do you think that the CCPA's main job should be to educate the judges?
I wouldn't say main job, should be one of them. How can you say? They can really take up anything,
Okay.
So motto they can take up. This
Fine, one of the main jobs.
advertisement.
Yeah,
and
one
they
of
will remove the entire ad. This is not really right for our people. It is wrong ad advertisement. It's a misleading advertisement. They will immediately say remove it or remove this product. It is injurious to people. That kind of a thing they can take, which is important. By the time it goes through the National Commission and so many for us, it will be the end of our life, because they can take it like this.
Anand, what's your take?
Well, as far as educating the judges is concerned, I think that is not the concept under CCPA, which has been introduced by Section 10. Here, the whole idea is how the consumer's interest would be protected and whether there is anything that is going against the interest of a consumer. Now, here issues would be where there are spurious goods being sold. That is
Yeah, but
one.
if I have a daft judge, that hurts my interest as a consumer. I don't mind corrupt. See, I'm totally against corruption in judiciary, right? But we are also very, at times very much impacted by stupid judges, aren't we? So it's better to have them, as part of the sensitization, you need to have them to educate us. Just, you had sensitization of male cops and more so induction of more female cops to deal with rape cases. So that was also one sort of curative measure. So likewise in this.
Complicated, I'll come to that.
Sure.
So, as far as the functioning of CCPA is concerned, the Central Consumer Protection Authority, which has got introduced by this new enactment of 2019, their idea here is to take up a larger view. In the sense, let us say there have been advertisements like Fair and Lovely, or such kind of misleading advertisements. You take this kind of a medicine, or you take this kind, use this kind of a product, and it is fantastic. There are people who have been endorsing Thanda Thanda, cool, and those kind of things. There have been advertisements where you can now start growing hair and those kind of things. So these things needed to be investigated, where an individual consumer may not be able to do that kind of investigation. So they have powers of even further investigation. And in such situations, to either have that particular advertisement modified or stopped completely, blocked completely, even the endorser who is endorsing is not spared. Even he can be penalized and punished, because have you tried the product yourself? If you are endorsing and making people believe that, okay, this kind of a personality has used this product and it's going to be fantastic for me too. There are so many products like, say Boost, add something into the milk and add something into your, for the child, and look how mature it becomes and strong it becomes. Those
They
things
can withdraw everything. They can ask them to withdraw all the products in the market. Those are the powers they have. It's like as a minister of the union minister of the country. They can take that. Otherwise, it's imprisonment. All that is there. So people have to now really be worried. It's very important. It's very useful, because by the time it goes through the usual courts and all that, it takes a lot of time.
Exactly.
You should actually file there. All these major things that you have in mind, it bothers you. In the interest of people, you should actually file there, and that will get a correct result fast.
Right.
When it comes to educating the judges and all, they are supposed to be selected from a class of judiciary who have been district judges, who are retired High Court judges, and who are retired Supreme Court judges. To assist the president, there would be another panel, let us say, of members, one of whom necessarily has to be a non-judicial member. The whole idea is what I initially said, Akbar Birbal justice, someone not just think from the books and from the brain, but also their heart to understand the situation. Maybe you penalize
pointed out that it was a boon for a
those kind of issues need to be addressed, particularly when it comes to medical negligence matters or even builders issues. People sell off their flats where they're residing in order to pay the builder, otherwise builder is going to charge them interest, and the builder doesn't deliver possession in time. Where is he going to go? He has EMI, he will also have some kind of rent to be paid, and he's out on this road trying to find every 11 months some new place to stay till that construction is ready. Now these kind of issues need to be addressed. Or insurance, the way they interpret things subsequently, that had to be addressed properly. So those are some of the things that need to be also understood, and consumer needs to be protected, where this new act has actually taken steps. I mean, the old consumer protection did have, but now we have the CCPA, which is specialized, having powers of investigation, search, seizure, also file criminal cases where and harm is found. someone
And
is
it's got,
doing
it's, yeah, the good part is that it's got a criminal flavor to it. So it's been a little bit more stringent.
Swapnil, if you
So it's,
really feel justice has to be done at all levels, two things. One is, of course, training them, because there is a training center in Delhi where they normally call all these people, a couple of times in a year and train them. That has been happening earlier, and I think they must do it much more vigorously to all the members. But what is much more important is you have to see that this is where you have to take a real good role across the country. So many benches, they don't have president, they don't have members. It is just sitting there without any work, adjourning dates. It's happening across the country. The act is fantastic act. This is
okay. You know what I'll do is I'll
have
take
to
a
do something on this.
Yeah, Rajalakshmi, what I'll do is I'll take a cue from this. We'll prepare a white paper on this.
Yeah.
I'll take assistance of the both of you as part of the IMC white paper. It will go that, you know, so many precedents are missing from this, because it's pointless to have these benches unless if you don't have requisite people, and also include these sensitization points that Anand pointed out. And, you know, the fact that also you pointed out. Now, as a concluding question on this seminar, I have first to a lawyer, what other changes do you expect or do you want to see in corresponding legislations? Because I'm not just happy with the revamp of this act. I think there are several other acts which you know, need an overall repeal. You know, those are OTO's legislations. Now, for example, you know, one of them was some you know, I was looking through some 2014 Law Commission report. In that, one of the acts was this Police Incitement to Disaffection Act, now which, you know, which has been lately in the news. That's okay. I don't want to talk about that as much as the, you know, there was some stupid act like Bangalore Validation of Marriages Act by some Sir James Redmond, who's probably not even alive. It's of 1934. He's probably dead now. So that's still on the statute books. So, you know, that he was supposed to solemnize certain marriages in Karnataka or in Bangalore. So, you know, things like that, they are still on the cards. You know, they're still on the statute books. You are debating that, you know, the death penalty should be there on the statute books or not, because it's anti-human and this, that, and the other. And, you know, you have Amnesty International and you have human rights, you know, jingoism about all those things. But one of the things that I wanted to talk about is that do you see or do you want certain corresponding changes in similar legislations which deal with the rights of the consumer and people at large in the civil aspect? And if so, which ones?
Can I first sum up in one liner the different kind of amendments that have now come, not amendments, but introduction of new things that have come into this act, which will probably cover some of the points which are not we have not discussed so far, and probably give us a chance to even think what more is required. One of the very important part, apart from CCPA and mediation that we have spoken about, is the power to review their orders, which was not there. So every time, even if there was some wrong order passed or some order passed which was some error in it, one had to file an appeal or file a revision and get that matter to come back to the same commission, district or whatever. So that one change that has come in, which is very excellent thing to come. Second very important part in section 66 is where there is powers given to the National Commission and State Commission to seek expert advice or to seek expert assistance. This also can be moved by a consumer himself by an application saying, in such situation, in such case, or in my particular case, let us say defective vehicle that has to be now assessed by someone who is an automobile engineer. You and I would not be able to say what is the defect unless you are actually feeling uncomfortable driving or the complications where the vehicle is being breaking down. So that apart, so such kind of thing has been brought in. Provision for mediation we have already discussed. Very important aspect that has now come in is product liability. This is something which is fantastic that has been brought in, and I believe in one way or the other it is making this act almost complete. Now we as lawyers or as advocates or judges, our role is not just that of standing in the court and talking about evidence and what is right and what is wrong to achieve maybe our victory. Our role basically in the society is as doctors of social behavior. How this particular enactment that has come up is going to actually have its implications, how it is going to be properly addressing the issues for which it is intended, and how it can be best implemented, and what is the lacuna only time can tell. Not just that, but with the changing circumstances, changing markets, changing way of functioning of the market, there is bound to be some kind of a review which is going to come, and that is the progress of law. That is how we have got so many enactments. Most of them, like you feel, are either redundant, or the best way to call them is maybe even stupid. But yes, but they do exist. And that is where we need to understand and change over. This is one of the very good provisions that have been brought in, stronger punishments when it comes, that is one, where the punishments, not merely imprisonment was one of the things for non-compliance, but where there has been a damage caused, like spurious goods because of which, or spurious medicines, or something that is expired, the life has expired, but that has been sold. Such kind of goods if sold, and if that has caused damage, then through a consumer can make an application to CCPA as well, and CCPA can investigate and take up the matter, and it would be their responsibility to take up the issue in larger interest, because it would be that entire batch of those goods that are sold. So such kind of things have been introduced in a very wonderful way. For
Okay.
filing an appeal, it would not be that anyone who is aggrieved can file an appeal for just for the purpose of filing an appeal because it's his right. No. Here, one will have to deposit 50% of the amount that has been awarded. And that is one of the very good things, that a person who is filing an appeal would have to first deposit that kind of amount, and the appeal, particularly from state commission to national commission, he would have to specify what is the point of law that is involved. And that was one more aspect. I find that to be a little, binding one's hands, because then a right where even factual matrix has not been properly considered would be sometimes an issue, or wrong interpretation of a certain order that is already passed by higher courts. Those could be some of the issues which directly only on the point of law an appeal would lie, is making things not very comfortable for me. But then these are some of the provisions which have been brought in, and which will have significant effect on what was the Consumer Protection Act earlier.
Okay, perfect. Thanks a lot, Anand. That was quite a great recap of this entire, act and how important this legislation is. Now, Rajalakshmi, your take on this? Do you?
I'm sorry to interrupt, Madam. May I just add one more line, which is also very significant. All these days, a complaint could be filed before the district or the state commission or the national commission, where the opposite party would voluntarily carry out business or reside. Now
Right.
there has been a change where even a consumer can file it to where he is residing, or where
Perfect.
he is functioning or doing business, voluntarily.
I hope that is allowed in other legislations as well, everywhere across, so that, it's only not the defendant resides, where the cause of action is arisen, where the defendant resides, or his place of business. I think that should translate there to other legislations as well. Now, Rajalakshmi, what do you have to say on the overall, framework, on the texture of the act? And do you think that as a jurisprudence, the Consumer Protection Act is a great headway in terms of consumer jurisprudence, as what we call, the Companies Act 2013 was a great headway in terms of corporate jurisprudence, and it's still seeing a lot of changes where people are working day and night to ensure that there is a business atmosphere created. Likewise, in this, given the fact that you have a background in advertising, your rather education in advertising from a United States university, what do you think are how do you look at this act, from a perspective of a judge, and also from a perspective of a layperson who is consciously aware of his or her rights and who does not hesitate to assert them?
Swapnil, actually, it's a benevolent act. I joined this only because it's a benevolent act, years back in the district court. At the time, the question of misleading advertisements and unfair trade practices were really not part of this whole thing. That is another reason why I didn't practice advertising. Today, by the time I was in the National Commission, I took advantage of unfair trade practices, and all the fake advertisements and all have taken it to under that, including even gold. People sell gold, saying, pure gold, but actually it's only 14 karat or something. This hallmark, now it has come, it's mandatory, it's all started at my time. Meaning I've taken it that way. So today, I think the new act has taken all that into consideration. I'm extremely happy. I think it's beautifully done. My only problem is I've understood these courts for so many years, and being in the National Commission for 10 years, I know that most of the district forums are not functioning. In the National Commission also, their members are not properly, fully there. The benches are not formed. In Maharashtra, it's in a bad shape. I mean, why should it be? Why all these governments are just not bothered? This is where you have to really put your mind into. It's a beautiful act. It should be done within 90 days or 100. It's small cases. Let them have some retired people, judges or whoever it is, who are free. Let them clean up all the system and bring it up to date. Old cases. I mean, even when I was Nikal kid, we had to decide. It is still continuing. It hasn't changed. That change hasn't happened. Act is beautiful. But implementation, all states have to implement it and make it very fast track. What is the point in getting justice after 10 years? District forum, appeal, idhar. What is the point? And I'm happy there's one judgment I gave certain amount. Supreme Court made it like 10 times more. But I mean, the same case. And I'm glad they've, affirmed my order. But I feel so bad. What kind of a torture it is for everyone.
Correct. I mean, oftentimes, the time to take, to reach the destination is much more than the time that you spend at the destination.
And they're not functioning. Because they're not functioning, everything is adjourned. It is terrible.
Right. I mean, this has been
rectified. You put your heart into it, things will fall in place.
Okay, got it. I mean, it's been a fantastic conversation. We always have the constraints of time, and I don't want to be hogging this, because I have to leave enough time for my next moderator.
Yes.
Who's going to be are very reputed two gentlemen on this aspect as well. And I ask Shelby to now, invite Vismay Shroff to give the thanks. So Shelby, you want to take that?
Yes, thank you. Thank you for that wonderful session. The thanks would be at the end. So now we will be starting with the next session. So I now request Mr. Anand Desai, Managing Partner DSK Legal and Chairman of the IMC's Law Committee, to take us through the second session, that is discussion on impact and implementation of the key amendments, as the moderator of the session. Over to you, Mr. Desai.
Thank you, Selby, and to the previous speakers, congratulations. Well done.
Hi, Anand.
I was trying to get on earlier, but Selby did not want to hear my voice at that time. So anyway, if you can also unmute.
Yes, sir. I'll be doing that. As you will be introducing, we'll be picking them up.
So I'll introduce Mr. Prabhavalkar first.
Okay.
He is a very prominent practitioner in this space for several years. He's a lawyer who has spent several years in practice. And like I said, he has in various courts, tribunals, for builders, for banks, and a variety of people. We're hoping to hear from him practical suggestions based on his experience as to how to implement this statute for a common, if I may call it, common consumer, and not a very high profile, expensive, big litigation, or just something the rich can afford and the others can't. And the point made, a valid point, that if it's going to take many years to actually see the result, is that really helpful? And the other thing I would like him to comment when we come to him is the act over-engineered? And what I mean by over-engineered, I think for a common man to understand his rights, the simpler a law is and the shorter it is, just makes it much more friendly for a common man, if I may call it that.
Yes.
Going into various sections and definitions and reviews and appeals. So we'll discuss that in a couple of minutes. And on a practical basis, I also wanted to introduce Vijay, and he's been very kind to join us. I know I saw his name somewhere, but
yes,
I'm here.
Hi.
Sorry, can you see me there?
Yeah. The reason I requested Vijay to join is we have a very new element in this new act, which is in respect of the product endorsements, the endorsers are also considered to be responsible. And we had the Maggie case a few years ago, and that is a classic case when a lot of flack was faced by a couple of celebrities who had been endorsing Maggie noodles. Ultimately, the whole thing went away, but it's a pretty stressful time. And I think that was one of the main triggers to bring in an amendment to the law. And what's interesting is also that we have already the Advertising Standards Code, we have some other rules which I'll talk about. So Vijay's background is interesting. He's an engineer, mechanical engineer, loves the, I would call it with passion, the entertainment industry, the music industry, and he manages several of the best known celebrities in the country. He's grown a business from nil when this was a very new and nascent area of activity in India. He's also a musician, he's a drummer, so very varied. And he's a consumer, as we all are. And I'd like to start with you, Vijay, in terms of the thought process. And when you look back, I think 25 years ago, we had professional models and we had professional actors. And the two did not cross over into each other's territory. And models really were meant to position a product or a service in a particular way. Stars are a bit different because they position themselves first,
Sorry,
not
sir.
just a product or service.
I lost you for a minute.
I said a film star positions himself or herself through experts like you, and then comes to a product or service second. It's not just pushing the product or service, it's their own character, their own persona that they add. Now, given the fact that they are effectively there to draw eyeballs, if I may put it that way, how do you see the perception now in them and in you as a manager of putting them out in a situation where they could be potentially soft targets to go against and liable as such?
Okay. Firstly, very, very scary to be in such a illustrious panel and very humbled by that. Thank you, Anand, sir. When you talk about soft targets and being a target, in light of recent events, I don't think it's that difficult to be soft targets in the Bollywood business. I think any celebrated personality is a soft target. But we just to sort of bring it back, I think everything has changed in the landscape of media and entertainment, right? Today, advertising is not just restricted to what you see on your radio boxes and as you're driving fast forwarding. It's also available on your mobile screen. But today, I think as and when this entire thing sort of blows up, the one thing, and brands are one of those pivotal vehicles we as agents use to position and plan for a celebrity imagery, right? So if somebody stands for irreverence, if somebody stands for urban cool, we go after brands who sort of speak specifically to those cohorts. Similarly, if somebody is mass market, we go after that. So for us, it's working with a brand is a shorter way of working with a film, right? You believe in the idea, you believe in the overall philosophy of brand, and you go in. So the moment, but our visibility ends with the marketing of the brand, right? I mean, just as any organization, our visibility doesn't go beyond that, right? We don't know what's happening in the factories. We don't know what's happening in the back-end data rooms on technology. We don't necessarily know, what's happening as the products are being shipped from point A to point B. So for us, what we are effectively looking at is you put a can of a beverage and you put a sticker on top of it and then you plaster a face on top of it. I think we are pretty much in the last leg of that. But if you ask us, what is the process of the beverage going in? Is it cold press, warm press, refrigeration? How does it get shipped? How does it move? The frank answer to that is that's not our business. We don't need to know that. Nobody in the world needs to know that. So tomorrow, while I do agree that responsible communication from a position of power for anyone who has it is extremely critical, in terms of any narrative, right? You want to say the right stories about films. I don't think the storytelling part of it changes. I think every influencer stroke celebrity wants to be seen a certain way in terms of, how he's communicating. But for us, we look at brands as a very, very key pillar. So if I was to have two goalposts of managing my talent's life. One goalpost will definitely be the work that they do for. Fair. Sorry, something happened. Anand, so you are muted.
Yeah. We are muted by mistake, I think. Go ahead.
So I think those are two goalposts that we really work with here. So for us, leveraging brand is extremely critical.
No, so coming back to what I was saying, today you are responsible to protect your customer. So when you put a customer out there, the way the law now reads, your client, if I may call it that, your client who's a celebrity is today supposed to be aware and have done their diligence on a product or service, because otherwise they are potentially liable if something goes wrong.
Anand sir, for me, I don't know whether the right and wrong of this is, and I want to tread on this very, very carefully. But I would just like to know, what do you mean by audit, right? I would like to. Sorry, did I miss something?
No, we could hear you.
Yeah. I'd like to know what we mean by audit, right? So, are you going to hold me responsible if the roof of a PVR cinema falls because my client is acting in a screen? I mean, I don't know whether that's so. For me, if you say that if a particular lathe machine in an automobile factory is default and something goes wrong on an assembly line, I don't know what diligence means. I mean, my only diligence is I know that product, I know it's healthy or I know it's unhealthy, I know what it does, I consume it, I don't mind putting my face on it, right? But if you ask me a question on whether what that means, I mean, I would like to know what diligence means. I would like to know, are we supposed to go onto factory floors? Are we supposed to understand the code behind, a cloud kitchen? Are we supposed to understand, so that's where the gray happens. Because like a consumer, effectively a brand ambassador is also a consumer. A brand ambassador is just amplifying his view as a consumer of a product he loves. Nobody's going to endorse a product they hate, right? I don't think that's ever a conversation. So I would like to, for me, where the entire piece kind of begs a little bit of clarity is, what do you mean by diligence, and how do you tangibly make that understandably visible and comprehensible to a talent you intend to bring on board? Because like I said, I mean, it's not in my place to understand, if you tell me that this is 0% sugar, I would like to believe it, but am I expected to then go to the factory floor and say this is 0% sugar? I mean, if that's what it is, then that's what it should spell out, then that's what the law should spell out. But I don't know how you can do that. I don't know how, if I'm putting my face to a real estate project, how am I supposed to gather or guarantee timely deliveries if the builder, has a financial problem, right? So I think that's where the gray is. And I feel unless you have clearer diktats on that, the law will be open to interpretation. And, as an agent, I mean, yeah, you can make it a law, but, I wouldn't know how to comprehend that entire data processing.
I would request Mr. Prabhavalkar to maybe comment on that.
Yes.
Because it's a valid point, and also a contract for the celebrity may run for a year, 2 years, 3 years. So technically you have to stay on top of the product or the service through that period. Please, Mr. Prabhavalkar.
Yes. First of all, as far as due diligence is concerned, I'm sure every celebrity who endorses endorses a product first enters into contract with the manufacturer as well as advertising firm. Now, therefore, up from that, the celebrity has his own agency also to make the due diligence. So, strictly speaking, that as far as due diligence is concerned, that is being taken care by his team. The celebrity himself is not responsible, or he doesn't involve himself for making the due diligence.
Yeah, so
now, my friend Mr. Vijay.
Yeah, he is the team.
Sorry.
Vijay is the team.
Okay.
For example.
Yeah. Mr. Vijay. No, that precisely I'm saying. Mr. Vijay said that what do you mean due diligence? Is he supposed to make inquiry about this thing, that how the product is made, etc.? Strictly speaking, he doesn't have to make such this thing. That first he has to ensure that the endorser has to ensure that the product, that whatever product is offered is this thing, that is manufactured by this thing, that proper methods, and it is not a misleading product. That's all. For every mishap or every accident which takes place, the endorser is not responsible. And secondly, as far as Section 21 of the new Act is concerned, under Section 21, subsections 4 and 5, that protection is given to the endorser. So the endorser doesn't have to bother about this thing, that the moment he endorses a product, he is responsible for everything.
So basically you're saying that once he does a basic understanding of the product
Yes.
or service.
Yes, through his team.
To his team. It's
Yes.
it's not an ongoing obligation. It's a one time, maybe after a few months, second time, but not an
Yes.
ongoing obligation for which he is answerable. That's what I'm understanding you to
Yes,
say.
according to me, it is practically not possible for him to make due diligence throughout his contract. Initially, when he that endorses his name to the product, that time he has to take the due diligence. But that he is not supposing that when he endorses a product, at that stage, if he has done the due diligence, and without his knowledge, consent, if any changes are made in the product subsequently, certainly he is not liable or responsible for the same. So ultimately, that he has to prove his innocence on the strength of evidence. Yeah.
So, which I hope that helps. No, you're on mute again. I don't know why we are going on mute periodically.
I don't think the admin likes my voice too much. No, I get that, sir. I mean, like I said,
Yes.
In matters of the law, and we have to be so cognizant that India is such a strong, influenceable country when it comes to celebrities. The greater the clarity, the better, right?
Yeah.
So even if you want us to do, like, I'm actually breaking it down, right? There's a manufacturing sector, and there is a service sector, right? So for me, it's going to be very clear that even when I'm signing, for example, if I'm signing a chips brand, it'll be nice to know, apart from the ingredient list that they claim. See, my best case is I can ensure we don't do testimonials, right? Like, I can ensure that we don't say stuff like drinking this will reduce fat by 30%, right? Or this is India's
Yes.
best. That I'm pretty certain we can control. But what I won't be able to control is this is healthy, right? This is zero sugar, right? Because if there is a process then I would like that same kind of pressure to be applied to brands and the marketing custodians and the CEOs and the promoter group of brands. I would like the big multinational cohorts to also be responsible with their marketing teams, because it cannot be a one-way liability only on the talent just because the talent is a fairly larger target. I would like the same, I would like to understand what are the disclosures that we get, at the time of endorsing a product. So if we are saying that this car will give the maximum mileage, right? What is the I might not be on the communication, right? But tomorrow there could be a standalone hoarding that just talks about the car's mileage, right? And then I get penalized because I'm doing that variant of that car. I would like to then understand what are the disclosures that can be made transparent from a corporate side. And now, Anand sir, the fact is, let's understand the corporate economy is no longer about the Fortune 500s and the multinationals. It's also about the venture-backed D2C economy, the new consumer and consumer tech brands who are, if you look at exactly what's happening in the ed tech sector, right? With all these new unicorns that are being born out of the educational technology system. If you look at what's happening on gaming, if you look at what's happening on fantasy leagues, I'd love for the laws to be a lot more clearer for us to be decisive. We have some states banning it. We have some states talking about things. It just puts us in a tizzy in terms of, what's right and what's wrong. And for us, we need to get it wrong, not even once, half. If it's wrong, if it's wrong for 30 seconds, it'll get, blown out of proportion. So we'd love to have that kind of disclosure come to us to take better and informed decisions.
So one thing we plan to do, as I think you heard the previous moderator say, is use sessions of this kind to actually make representations to the government as a chamber of commerce, who they tend to take more seriously than individuals. Yes, Mr. Pravalkar, any other? I also want to ask you separately on the review process, because that's another round of potential liability.
Yes. Though I've not followed your question.
No, I was saying that today, what Vijay is saying is that I don't know enough as to what is expected of a brand endorser. That is still a clarity of law that's required. That is stage one. But that doesn't end it. You have a review, you have a second stage. So what is your sense on the process? Because a person could be under a cloud for a long time.
Yes. So first of all, as far as the celebrity is concerned, when he endorses a product, first of all, see that, for example, now supposing if Sachin Tendulkar is endorsing the advertisement of the Parle G biscuit. He simply say that I like Parle biscuits. He doesn't take guarantee, or he doesn't induce the customer or general public to eat the same because it is very good. He simply says that I like the Parle G biscuits. So in such scenario, that it all depends as to what kind of what kind of inducement is made by the celebrity. If he doesn't induces the general public to go for that product, then certainly is not liable. So therefore, that has to be taken into consideration. And as far as
so
yes,
that's also gray, right?
Yes.
When you come to inducing, how do you define what's inducing and what's not?
No, that precisely I'm saying. I give you an illustration of this. If I simply say that that I eat this, that doesn't mean that I'm recommending you to eat it. I simply say that I like this product. That's all. So in such scenario, if you eat the product and if you don't like it, or if you find that it is a misleading advertisement, will it amount to misleading advertisement? Even that needs to be considered. So first of all, merely introducing or including this field under Consumer Protection Act is not suffice. There has to be proper guidelines, and there has to be the proper proper guidelines for this kind of inducement. And certainly when this will be decided once this kind of complaints are filed. The court will decide this on the strength of evidence, on the strength of other material which is put before them. As on date, as you rightly put it, there are gray areas as far as this kind of this thing is there.
What I'll do is, Vijay, I'll send you what we are proposing to submit to government. Anyway,
that'll be awesome, sir.
You'll have inputs to give, which will be.
We've been having a lot of murmurs on this. This will be awesome. Thank you.
Yeah, I know. Mr. Pravalkar, any other significant things you feel in the new act that's going to make it easier for a consumer to actually get a redressal?
On the contrary, I am of the view that it was absolutely not necessary to introduce new act. As far as old act was concerned, there were sufficient sufficient
protection.
They could have introduced this 2-3 this thing that like central authority and this thing, the mediation, etc. in the old act itself. Now by introducing this new act, in fact there will be more chaos in this thing, and the consumers will find it extremely difficult to handle the situation. Now I'll give you 2-3 illustrations. As far as old act was concerned, under old act, under section 11(1) of Consumer Protection Act, the filing of the complaint before district forum, state commission or national commission was depending upon the compensation which is claimed by the complainant. The section provided that whenever the complaint is filed while conferring the jurisdiction on the district forum, the value of the service, or the value of the goods or service as the case may be, and compensation was to be taken into consideration. Now, for example, if the complaint is to be filed on the ground of deficiency in service or unfair trade practice against the builder. Now, if the value of the flat as per the agreement is 50 lakhs, but in addition to that, under old act, in addition to that, if the consumer was to claim any compensation, or the compensation interest or damages, etc., then that everything was to be taken into consideration while the conferring the jurisdiction. Now, the jurisdiction of the district forum was only 1 lakh, only up to 20 lakhs. About 20 lakhs up to 1 crore, the jurisdiction lies lying with the state commission, and beyond 1 crore, it was before National Commission. Now, as far as new act is concerned, they have introduced the section 34(1). Under 34(1), the jurisdiction is to be conferred on the strength of the consideration actually paid. Now, for example, supposing if the value of the flat which I have booked is 5 crores, but before filing the complaint, the total consideration paid to the builder is less than 1 crore, then irrespective of the claim which I am making in the complaint, that complaint lies before the district forum. Likewise, if the consideration paid is up to 10 crore, it goes to state commission, and beyond 10 crore, it lies before National Commission. Now, by introducing this section, there are lots of complications which are going to be there. First of all, the district forum or district commission, now under the new act, this district commission will be the overburden or flooded with the many complaints, because 80 to 90% proceedings will have to be filed before district forum. For example, if the insurance claim is to be filed for for repudiation of the insurance claim. Now, whenever that proceedings are to be filed against the insurance company, what is important under new act is payment of that premium. Now, we all know that payment of that premium will never exceed 1 crore. So naturally, even if the company intends to file the complaint worth that claim worth 100 crores, that complaint will lie before district forum. So similarly, as far as medical negligence is concerned, that whenever we pay the bill is not going to exceed 1 crore. So irrespective of the claim, even if claim for the damage or compensation is 50 crores, the complaint will lie before the district forum. Then apart from that, under new act, under section 40 of the new act, the powers of review are given to the state commission and the district forum and state commission, which were not there in the earlier act. The one more aspect is under section 41 of the new act. Whenever any appeal is to be filed against the order passed by the district forum, you need to deposit, the aggrieved party needs to deposit 50% of the decretal amount. So naturally, that whenever any orders are passed, the aggrieved party is not likely to approach the state commission immediately, but is bound to take chance by filing the review. And in such scenario, there will be these district commissions will be overburdened with the work. Now, try to appreciate one more aspect of the matter. As far as president of the district commission is concerned, he is a retired the district judge. Question is whether he is capable of handling the claim worth 100 crores or 50 crores as the case may be. And as far as National Commission is concerned, since under 34(1), that complaint lies only on the strength of payment, there will be hardly matters where consideration of more than 10 crore is paid so as to file the complaint before National Commission, unless it is a class action under the Act. class action is class action is where the company, that group of flat purchasers files the complaint against the builder. In such scenario, the total consideration paid by 100 or 150 flat purchaser needs to be taken into consideration, and only in such scenarios the complaint would lie before National Commission, the National Commission. Now that you started this with first this thing, that anxiety, that how one should give the this thing, that more this thing to consumers. Because that act has to be consumer friendly. Certainly the old act as well as new act is consumer friendly, but unfortunately what is happening is, first of all, there is no the proper infrastructure provided before district forums and state commission all over India. Because I travel extensively in last 28 years, I must have conducted matters practically in every nook and corner of India. And unfortunately, everywhere the things are, barring few this thing like Punjab and this thing, there are this thing that adequate this thing are provided. But otherwise, everywhere, even in our Maharashtra, for the want of infrastructure, the complaints are remaining pending for years together. So that when you are this thing, that making any representation to the government, the first and foremost request which you need to make is to provide proper infrastructure. Now, in last 28 years, on many occasions, the petitions are filed in the High Court, our High Court. And our High Court has tried to intervene in the matter, but ultimately they don't get the proper support from the state government, because there are always issues about the funds. And with the result, now as on date, even in Maharashtra, most of the complaints, you can see about 40 to 50% district forums are not functioning for want of infrastructure. That is one. Secondly, under the old act as well as under new act, the complaint is supposed to be disposed of within 90 days. But unfortunately, what happens is, even first notice is not issued within 90 days. That is a problem. So even you need to take up this issue with the authorities. Then thirdly, as far as this advertising field, etc., is concerned, these are the new fields, the new field introduced under the act. And as far as this is concerned, that there has to be request to the government as well as the legislature to offer that rules which will include the guidelines to decide this kind of matters.
Just one thing.
So these are.
But I think Vijay would also come in. The celebrity
Yes.
endorses a product. You gave the example of saying, I eat or I like to eat the biscuits. But the celebrity is not given a script. The advertising agency normally gives a celebrity script and says, now say these words.
Yes.
And that is where the challenge starts, because then either you are willing to say those words or you're not willing to say those words. Vijay, correct me if I'm wrong.
Yes.
Yeah.
They have a choice of saying what they want to say, correct?
Yeah. No, I think the fact of the matter is, I think this stuff is a little gray. There's no doubt about it. Because I think the fact of the matter is, if you're selling a limited edition pack during Diwali, right, your product proposition is going to be to sell the limited edition pack during Diwali, right? Or if you're doing an end of season sale, you're going to talk. Let's talk very tangibly. I think where most of these discussions really go off is when you don't break it down to the binary of reality, right? It's a 0 and 1 situation. There's no gray here, right? Because I don't think you can have a law for cars and not have it for chips. I don't think you can have a law for Swiggy and not have it for Unilever, right? I think they're all the same. So I think what we effectively need to do is understand that what is the thumb rule of communication. Does that mean advertising with a talent as a whole does not carry any product proposition? And that's a conversation. Does it mean that you can't sell and it's only about a thought? So, getting married is warm, or, celebrating with your old parents is warm. But, does it mean that everything becomes open happiness, which is a, esoteric broad statement? Or do you do big billion day sale, everything available at 50% discount? Because tomorrow, how is a celebrity to know whether a guy who's selling a dishwasher has given 35% off, or has run out of stock, or has given you faulty goods. I mean, you are trying to form a law where the person you're expecting to abide on it neither has the control of the law, nor does he have a control of the supply chain, right? It's literally like saying, you're driving, and because you're in a car and somebody else bangs up on the road, you're also liable, right? So I really don't know how any of this will work unless you put strict guidelines, right? And it's okay to put it. Like, for example, a state to take a call that online rummy is banned. For good or for worse, it's a very clear diktat. You cannot do this, right? So today I'm very clear. I cannot do this, right? In some parts. But for it to be, when I'm handed over a script and you're trying to then control every single copywriter in this country, every single creative director in this country, and then I really feel this conversation is not on the talent. I think if you look at the funneling down, the sedimentation process, what you are leaving in your glass is that of the talent. But the funnel is actually the brand, the marketing head, the advertising agency, the media company, and then the talent. I don't think it works the other way around. Right? So it has to be everybody in that value chain who gets a certain diktat. Otherwise, no one does. It's unfair to just pull out the last guy in the wheel just because he's famous and say, here, now you're responsible. Yeah. By no means am I saying can they be irresponsible. That's also not what I'm saying. Like, I'm not a fan of testimonial-led ads. Fair enough, right? I'm not by no means propagating, doing something that may not be right or wrong in that sense. But what I'm saying is, for it to bring in more tangible controls, it has to be fair to the entire ecosystem. It cannot be hooked onto just one person. Because then my conversation is tomorrow, even if you're not using an influencer, you're using a model, please sue the model as well. Yeah. Because he's communicating that, right? Right. Yeah. And please sue the ad agency behind it completely. Now the ad agency guy will say that is, why should the entire agency get sued if one client wants this? It just leads to so many grays that you really can't. I don't know where it will start and where it will stop.
And I don't believe, I may be wrong, I don't believe anywhere else in the world is the celebrity considered to be liable.
Yeah.
You have to disclose, it's an advertisement, that I know. In several jurisdictions, if they don't actually want to say I consume the product because they do, they have to disclose it's an advertisement, which puts people to notice that this is something is just being paid for and not actually a consumer of. But you're right.
Digital media has done. You have those little paid ads.
Correct.
Now how I choose to make my money using my commercial time is completely on me. What are you going to do tomorrow when the influencer economy booms? The fact is, now you're only talking about celebrities, but YouTubers are getting famous.
Yeah.
Instagrammers are getting famous. Tomorrow, if an Instagrammer makes deep fried chips and he wants to sell deep fried chips, saying this is the world's most sinful chips. The fact is, it's unhealthy. It's got a lot of oil. You can get diabetic. But are you going to tell them not to promote it? Because this is a bottomless pit. Because understand, with digital media now at 20,000 crores of media budgets, today your celebrities are not just cricketers or Bollywood stars. They're also digital stars. How are you going to control that YouTuber?
Yes.
How are you going to control that Instagrammer? Now not TikToker, but whatever becomes the new medium.
Yeah.
Going to be so unless you make a all and sundry rule, and it has to be one size fits all. Yeah. It has to be for that Telugu influencer as much as it is for a Shah Rukh Khan. It has to be comparable. It has to be it has to be at parity. Otherwise you're just saying you're following the hierarchy of popularity and then convicting people accordingly. It doesn't make sense.
Yeah. So I think safeguards is a big factor. I think we should be making
that is one.
Safeguards and quick.
Now, as far as section 21 is concerned, if you peruse this section 25 21.5, that I'll just read out. It says that no endorser shall be liable to penalty under subsection 2 and 3 if he has exercised due diligence to verify the veracity of the claims made in the advertisement regarding the product or service being endorsed by him. So therefore, this is the clear-cut answer to our first discussion, that here, that as far as endorser is concerned, when he endorses a product at that stage, he has to take the due diligence. That is one. Secondly, if you ask me, there will be more responsibility on the lawyer or solicitor representing this endorser to prepare a proper document, because when you enter into the contract, the ultimately, as Mr. Vijay has rightly put it, that it is just not possible for any celebrity or model to know the entire thing about the product. So therefore, when the agreement is entered into, or when a contract is entered into, at that stage, the manufacturer or producer will have to provide the indemnity to the celebrity or that professional model. That can be done. And secondly, that these provisions has to be taken very seriously, for the simple reason that unless the other acts here, there is 1 year total ban on the celebrity for that endorsing the misleading product. And if he continues with the same, that next time the punishment is 3 years and the penalty is from 10 lakh to 50 lakhs. Apart from that, apart from this, the provision under 23, that since this advertisement has been introduced in the new act, the straight away the consumer or any citizen who buys the product worth 10 rupees is capable of filing the consumer complaint, because apart from this central agency, that direct complaint is tenable. And under direct complaint for non-compliance of supposing if the order is passed, the celebrity doesn't take this seriously, and if any adverse order is passed and no appeal is filed, or the order remains, then there is a penal provision also, by which he can be sent behind the bars for 3 years, up to 3 years. So therefore, this provision has to be this provision has to be taken very seriously, and for which, first of all, there has to be proper guidelines. So guidelines that you must they suggest to the authorities to introduce the guidelines to interpret this section, and ultimately the courts will interpret this. But in the meantime, that can be done.
I think this is helpful. I think, Vijay, the points you made are very valid. It's now a spreading kind of an endorser. It's not just the big names. And many of them may not know what all this means.
I mean, the influence economy is here. Let's not forget it. And if you're looking to go after people with influence and you want them to be responsible, like you have censorship, which has now become pretty clear.
Yeah.
I think that will be the next thing. What does that mean for OTT? But I think when it comes to talent and brand endorsements of any and all shape and forms, I think you have to keep the entire cohort of influencers. So that's how I would like to differentiate it, not just celebrities.
So it's a very good point. I think we should make that point also. And the numbers are growing, I guess.
So I'll also come to a point in saying, Kwan has just done this. We've launched our own influencer marketplace called Big Bang Social. Today, the fact is, a marathon runner with 2,000 followers is actually more trustworthy than a big celebrity for a nutrition company.
Yeah.
Right there. So these guys are getting coupon codes which says that you'll get 10% of product of the spoils. Now, if you ask me, that's where the infiltration of actual consumption happens. Right? Because I'm following that mother who has 2 kids, who's a runner, and I want to see how she does it. Right? She's not a celebrity. She doesn't have a 24-hour house help. Right? She works the way she does. I want to know what that mother is doing right. Right? And that is the mother who is influencing purchases. She's not influencing branding. She's actually influencing the purchase of a product.
That's true.
Now, if you're going to say that is illegal, that's legal because she's not celebrated, but she's influencing purchase directly. The influencer economy is not marketing. The influencer economy is social commerce. These are all places where you're affecting direct purchase. You're not affecting imagery. How are you going to control that? And that, like, I mean, at 1 lakh crore of digital marketing in the next four years, even if I take 5% of 1 lakh crore, that's $1 billion industry of influencers, not including Bollywood, not including cricket. So imagine, how do you do it in China? When somebody in China on a storefront is selling $35 million worth of product on one day on a sale, is that person liable? She's not a movie star.
Yeah.
She's not a sports star. So I just feel that when you come to the law, if you're doing this with talent now, in the next 2 years, you'll have a problem saying, yeah, what is this? Now, how do we deal with this?
That's
this
a
is
very
so
good
much
point.
wider and deeper.
Yeah, yeah. It's been very helpful, and we are sort of running out of time.
Thank you, sir.
To ask Vismay to give a vote of
Yeah,
thanks.
thank you.
So much for this, and I will certainly send you
Yeah.
the paper we come up with, which will not be in the too distant future.
Yes.
Thank you, sir.
Thank you.
Yeah. Thank you. Thanks a lot.
Vismay is on mute, I think.
I have to mute.
Thank you for unmuting me, and thank you, Mr. Anand Desai, for allowing me to present vote of thanks. It is my proud privilege to propose a vote of thanks for today's event on the digital session of the revised Consumer Protection Act, the Amended Act, planned and executed by IMC's Law Committee. I thank our panel speakers, Mr. Anand Patwardhan, former President, Consumer Bar Association, Mrs. Rajalakshmi Rao, former Member Judge, National Consumer Disputes Redressal Commission, Mr. Shekhar Prabhavalkar, Advocate, Mr. Vijay Subramaniam, CEO, Quant Talent Management, for their willingness to participate and for giving us the flexibility of their time. On behalf of the Indian Merchants Chamber and on my personal behalf, I'd like to express much gratitude to Jimbrick Consulting OPC Private Limited for sponsoring this event. I would like to thank Mr. Rajiv Poddar, President of the IMC Chamber of Commerce and Industry, the IMC dignitaries and members of the IMC Law Committee for making today's session possible. I would like to also thank our chair, Mr. Anand Desai, and Mr. Swapnil Kothari for moderating today's captivating session. As we conclude, I am sure that today's session has equipped participants and the public at large on the latest major amendments to the Consumer Protection Act of 2019, and that it will protect consumers from unjust market practices of various companies. The Act is totally redesigned, keeping in mind the importance and value of consumers and to ensure the well-being of the consumers. I thank everybody once again.
Thank you so much. Thank you.
Thank you.
Thank you all for participating.
Thank you.
Thank you,
Hi,
everybody.
Anand.
Thank you so much.
Hi, Anand. I mean, both Anands, of course. Hi, Mr. Prabhavalkar. Nice to see you. Looking fit.
Thank you. Bye.
Thank you.
Bye. Bye, Anand.